Perfect for recording. Thank you so much. Who was that again? Okay, you're already the MVP for today, whoever reminded me. Thank you. Perfect. Karina, I think you did this last class too. Perfect. Thank you so much. Appreciate that. So yeah, just Tom will be logging on at around 6:15. If he logs on earlier, then we may just kind of introduce him right away so that we can get started. Just to kind of preview what's going to happen in the class today as everyone files in. Thank you, everybody. We have a bigger group tonight. In our agenda, we are also going to, of course, discuss the only two cases today because again, we had a pretty short turnaround from last Thursday. So two cases. Hopefully, everyone at least read maybe both cases. But I know the Townley case. That's a pretty fun case, actually, right? We all can relate to that, right? We all have worked, most of us probably at some sort of retail or fast food earlier in our careers. Reimbursements. I know Karina, props to you for mentioning this. It's a very key area. I was going to discuss this anyways, in addition to our big four. But we'll go through analysis there. And then, of course, Donahue, where the employer was actually, in a way, kind of sometimes overpaying its employers, right? Or excuse me, its employees by rounding up, but then maybe not having the best time records. So we'll discuss that. I know that's kind of a more dense case. At some point, we'll weave in a 5 minute bio break. I think that's a fair request by everyone, and I know it helps me out as well to kind of recalibrate for the next hour. And then, of course, our first class hypothetical. So, what if I was in your shoes? I would love this class because you know why? There's no assessment. Like when I was first asked to teach for this class, and I know it's a unique program. It's not necessarily for degree, but like there's a final exam. Like how would I motivate students, to really get involved and without a final exam assessments, right? But also to gauge where you are, right? How do you really understand this? Of course, I expect some basic participation, preparation for the class, and I was betting on all of you to do that, and you are doing that. But why I'm kind of going extra is that these exercises, right, having guest speakers by kind of gauging them and kind of tracking what they're saying, that is your assessment. It's hopefully again you care about not just getting a certificate, right? This something on your resume that just you have credit, but you actually immerse yourself in this class. As I mentioned, my Spanish teacher, Mr. Alvarez, my football coach, he gave me all A's, but there was no test. And I wish he would have given me more work because I can't speak proper Spanish, even though I kind of can, have conversational Spanish. But that's what I'm counting on all of you as professionals, as leaders, as executives to really care about your learnings and kind of learn a few things or two from our class. And that's why, again, we have these hypotheticals in class where you also show your leadership skills, your analysis, but also see how you've taken the lessons and the learnings from the first three sessions to now apply them as well. So I'm looking forward to that. I'm really excited for this class. I woke up today like it was like going to Disneyland for the first time, seeing how all of you would perform today in our class. And then after this class, we're going to be halfway done with the course. So any questions so far um, before we move on? And then so what'll happen is I'll wait for Tom Lance to log on. I think he may be on already. I see a hand up. I'm just trying to toggle between my screens. I think it was SB Sheila.
Yeah, Sandra.
Sandra. Sorry, Sandra.
I was just wondering if you could tell us more about the final exam.
Oh no, there is no final exam. That's the whole point. There's no assessment.
Oh,
Yeah, no, that's kind of so why I love law school and why I didn't love law school was that like it's all reading. If you love reading, like I did growing up, I read books about dinosaurs, about sharks, third grade, whatever it is, and then law school, you're just reading cases. Except something has to give, right? Except you only get one shot, like the Eminem song, at one final exam. So you don't know where you stand. That's kind of like now there's a movement towards midterms, papers, but there's no homework in law in like law school. It's just okay, you expect to keep up with the reading, do outlines as well. But no, there's no final exam, there's no assessments in this class. It's really just again me betting on all of you to be the true professionals that you are and engaging. And so that's how it is. So yeah, thank you, Giera. That's right. I love your note about reading. So yeah, that's kind of what these cases are because again, I could just lecture to you and yeah, you'll kind of learn a few things, but I don't think you're gonna really feel as immersed. And that's kind of again how I do add rigor to my classes, whether it's even without an assessment. So to clarify, there is no final exam. It's just being professional, showing up here on time, being prepared, contributing, listening to others, and just kind of doing what you've already been doing as well. So Sandra, yeah, did I answer your question?
Yeah.
Perfect. So no final exam. Just be ready because, for example, um, I'll try to do at least two more breakout sessions, hypotheticals that you saw. So I think as we let's see, let me check the chat. Okay, thank you. So as we wait for Tom Lentz, let's begin on the Townley case. We may have to kind of be flexible and kind of stop in the middle of our discussion if that's okay, so that we can have Tom come in at 6:15. I'll introduce him and then we'll start again. So can I have a volunteer, please, for our class discussion of this case, the Townley versus BJ's case involving a reimbursement before I call on somebody? So I saw two hands raised, so we'll start with both of you here. Who do I see? Actually, four hands. This is great. So I have Azra first, Heidi, Veronica, and Shelley. So in that order, can I obviously we know that we've read the case. So Azra, who are the parties in this case?
The parties are Krista Townley and BJ's Restaurant, and she's suing them for reimbursement of shoes, but the shoes weren't really like specified that they're going to reimburse you. They kind of like hinted that you need these shoes, but they never said, "Oh, we're going to repay you for these shoes." And she's suing because she wants the payment for the shoes as a requirement of the uniform, but it was kind of
Perfect.
like with an I said with an undertone. And I think
Yeah.
she officially lost the case, as from what I understood from reading the case.
Good, good. So let's back up. Thank you. You covered a lot there. Thank you. So why did the employer BJ's have this policy of shoes? And can you explain to us exactly kind of the policy of like what the shoes were required to do?
The non-slip shoes, like more of a safety measurement for work,
Yeah.
because she's a like a server hostess kind of thing. She's on the ground, she's moving back and forth, so it's kind of like a hazardous thing.
And what about like wearing them off hours, on hours? Like, are they, what the flexibility perhaps to wear any shoes? What, can you explain more? Kind of what the company allowed?
I mean, I think the slip shoes were necessary for like just for work hours. She could wear whatever after work and before work, but for it was part of the uniform, from what I understood. It was like more of a uniform measurement, like it was a requirement for the uniform.
Perfect. And I have a couple more questions for you, and then I'll move on to Heidi and Veronica. You're doing a great job, and then Karina too. So, um, what what kind of lawsuit is this? Because no attorney would just want to represent one client for a pair of shoes, right? What, $50, $100 for shoes? What kind of case did is this called
Is it
when
is it like a class action kind of lawsuit kind of thing? Because I know the shoes were like to avoid slips and falls and accidents. So it's kind of more of like on the brighter range, but I don't know if this would classify as a class action
it is?
lawsuit.
Yeah, yeah, I think it's called
Oh,
even
okay.
Paga. So we'll talk more about that. Like, for example, Lenny Sansanowitz, our keynote speaker, he'll discuss this further. But basically, last question for you. How many stores roughly did they say BJ's had? I think nationwide or statewide. There was a number that was in the opinion.
It
So it's a
was
pretty big company, right?
63. It was 63.
Okay, so Tiara, thank you. But so again, the community norms in this class, just wait as everyone has their hands raised. So just make sure to raise your hand and I'll call on you. So I see you behind Karina, Shelley, Veronica, and Heidi. So Azra, do you agree? It's 63?
Yes.
Okay, thank you, Tiara. And then we'll move on to you. Thank you. Great job. So perfect. So now Heidi, what else? What else should we before we kind of go into the analysis?
Yeah, I think she did a great job summarizing. I would just add that the the safety policy that she was mentioning required that all hourly employees or restaurant employees wear a little bit more specific shoes. Like, yes, they were slip resistant, but they also had to be closed toed. They also had to be black. So it didn't say that it had to be a specific brand, but there were requirements for the shoe. So that
Excellent.
would be a little bit more niche.
Great. Oh yeah, no. Again, we'll talk more about how some of us may have worked in similar establishments. But I see it's 6:15, and our first guest speaker, Tom Lenz, is here. So I took note of who had their hands raised, and we'll come back to this case. But out of respect for Tom and his very busy schedule, I want to stay on track. So let me introduce Tom Lenz. I think Tom, I saw you, so let's make sure that um, you're here.
I am here.
Um, Thank you. So Tom is a mentor, a friend, a colleague of mine since 2018. So Tom and I are active members and leaders of the California Lawyers Association's Labor and Employment Law section. We're part of its executive committee, where Tom was the chair of the whole committee, and there's about at least, I think, 7,000 members, law students, some judges, attorneys that practice on all sides of the aisle, plaintiff attorneys, defense, union, management, neutrals, workplace investigators. So Tom has an impressive resume that we won't have time to go over, but I know he's a proud alumni of Marquette University for undergrad, and Louisiana State University Law School. Is it the Hebert School of Law? Uh, uh, Named after namesake of one of my favorite quarterbacks, Bobby Hebert of the New Orleans Saints, a 1980s, 90s reference there. And as a fun fact about Tom, he's a world traveler, but I always catch up with him on his accomplishments, especially completing the Camino de Compostela, or the Way of St. James walk, if anyone you have heard about that, where there's many routes to take. I guess the Spanish route, Portuguese route, French route. So Tom is just an avid legal expert, but also health enthusiast as well. So that's kind of where he brings mindfulness, etc. But Tom is I know my go-to expert when it comes to labor law. In fact, he's a professor at my other law school that shall not be named, or I'll say at USC Law School, where I also teach of labor law. And so with that, Tom, I shared with our students your amazing background, but also kind of the key points that I'll share here, and then I'll add you as um, a co-host as far as kind of the goals. Basically, I ask students, okay, if they're where are they from, a union or non-union employer, but they should still listen to you for many reasons, right? Among them is protected concerted activity, NLRA, which we'll discuss further. Also, though, kind of unique wage and hour issues and intersections between um, labor law and our class topics. So with that, Tom, I turn the floor to you.
Thank you, Erneo. It's a pleasure to be here. I am really grateful for the opportunity to speak to your class and hope to be a resource and to answer any questions that you might have in the available time. Just a little bit of background on me. I grew up in Illinois. I ended up in California, and I tell my students why, because I learned Spanish. I am bilingual in Spanish, and that was my ticket to a career in law in California. And I lived in Spain for a while during college, but every day in my job, one way or another, I use Spanish. And I went to work initially for the National Labor Relations Board, a federal agency that you may have heard about. And, when I went into this field, people asked me, isn't labor law dead? Aren't unions dead? And I said no. And I've actually stayed busy in this line of work for going on 38 years. I was uh, at the National Labor Relations Board for about 3.5 years, and I've since then been at the same law firm. So yeah, we're going on 34, 35 years at Atkinson Andelson. I work in Pasadena, and I advise employers on dealing with labor issues. And most of my clients are non-union. And you may say, how does a labor lawyer work with a non-union employer? I'm often explaining, training, reviewing, and adjusting policies to deal with the rights of the unrepresented employee in a non-union environment, because federal labor law provides protections to employees not only to form and join unions, but also to engage in what we refer to as protected concerted activity. And that could be, one employee trying to spur on other people to demand higher pay, to improve working conditions. It could involve group activity where people engage in a walkout or what we would commonly refer to as a strike. So one of my first cases when I was at the National Labor Relations Board involved a group of janitors that walked off the job in the middle of their shift and in broken English actually told their boss back at the home office, "We want more pay." And the boss said in broken Spanish, "Get out of here or we'll call the cops." And the company said they quit, and the government, who I represented, said no, they were fired because they engaged in the strike activity. And after a trial, we won. It was a six-figure verdict, which was a lot for these employees making minimum wage. And it really just goes to show you how important the protected concerted activities are, even for the unrepresented employees. And I do spend a lot of time on things like negotiating labor agreements, interpreting labor agreements, because even in the unionized workplace, as you may be familiar, a lot of the same sorts of issues will pop up. People who believe they weren't properly paid, people who believe that maybe they were disciplined or fired in violation of a contract. And the setting may vary, but the issues are largely the same. And the applicable rules of law are what often comes into play. Because labor law is in many ways federal and preempts what goes on at the state level, we occasionally get situations where someone files a wage and hour lawsuit or a wrongful termination lawsuit or some combination of those things. And if they sue in state court, that is something where I'm often talking with my colleagues, the litigators in my firm, saying we need to get this into federal court because we have a labor agreement that enables us to claim preemption and to get out of state court. Usually you get a quicker resolution in federal court, and the plaintiff's attorneys don't generally like to be there. So if you're on the defense side, it's a better position in most circumstances to go there. There are a number of issues under California law where the legislature and the governor have put into effect rules encouraging employers to be signed to union agreements and providing certain exceptions to the general rules that apply to California employers. I believe I heard mention a few moments ago of the word paga. I believe that came up. And as a Spanish speaker, paga to me means pay. And it is a very apt name for a law that really energizes and provides a platform for wage and hour litigation. And California has actually enacted, at least for the construction industry and possibly for other industries to come, an exemption from PAGA if in your labor agreement you have appropriate language that would say you have an alternative dispute resolution process. In other words, a grievance process, an arbitration process where you can address those issues. So for an issue that plagues employers, PAGA claims, at least in that industry and possibly others, based upon the example that's been set, that's often how people go to Sacramento and lobby for new laws. Hey, it worked over here. Why not somewhere else? It's something to be aware of. Some of the common issues that we will come up with, might involve things like overtime pay, where maybe there is a distinction from the applicable state rules. There might be premium pay. There might be shift differentials where depending upon what time of day you're working, maybe you're working a shift that nobody wants to work. It's considered a lousy time to work. And maybe your labor agreement will enable you to get a higher rate. So if you have people that are hopping around from one assignment to another, maybe their schedule is erratic, you might find that there are misunderstandings or disputes over things like premium pay under a collective bargaining agreement. But those are some of the common things that will pop up as a matter of collective bargaining. And yeah, the thing with labor law and with the union setting is the union represents the employees. The union will have certain goals when it goes to the bargaining table, typically every 3 years, and it will advance the goals that it feels are winnable and appropriate. It may not pursue everything all the employees want, but it will do its best job typically to achieve what it feels is a win and progress for the employees. So your wage increases, your benefits and so forth will advance based upon what's sustainable probably in that marketplace, or at least for a particular employer. Many of the labor agreements that I work with involve something that is maybe industry wide or area wide, possibly multiple employers signed to it, like in the grocery industry or in the construction industry, sometimes other industries, in maybe education, for example, or healthcare. So we see different efforts that might set a higher standard than what the law typically applies. And that's honestly one other reason why preemption may be appropriate, to take it out of the usual context of state court litigation and to give more respect to the labor agreement and the bargaining relationship that the employees chose. And that provides respect for what the employer negotiated and agreed to as well. Another thing about labor agreements that is different, perhaps worth mentioning briefly, is that they do have grievance and arbitration processes. And I mentioned earlier on with the non-union issue I raised that employees can go on strike. The janitors did in that case I litigated. They were non-union. And I think many times people think of union environments as being places where there are strikes. That may happen when an agreement expires, but normally your labor agreement has what's called a no strike clause, and that's to ensure that work continues even if there's an issue. And the trade-off, according to federal labor law, for a no strike clause is a grievance and arbitration provision, which means that the parties have selected a method to resolve disputes. And if an issue arises under the contract, the parties agree to follow certain steps. And if they can't work it out amicably, then they will take it to an arbitrator. Sometimes the arbitrators will be chosen. You'll have maybe a list of 5 and you can pick one, or other times it's up to the parties to work together to select one from other resources. But this is a way to maybe get more efficient resolution of disputes. And when employers talk to me about possibly having a union agreement, is it a good thing or a bad thing? I say, if it can keep you from getting sued, I think it's a good thing. So I'm a lawyer that likes to help my clients avoid being sued. I think there's value in that. So there's even a way to sometimes get lawsuits on other issues, not just wage and hour, dismissed based upon what is in the labor agreement and what the grievance arbitration language will cover. So I won't go too deep into that, just in the interest of time. But One other thing I'll mention before I turn it over for questions, if you have any. There was a Supreme Court case that came out in 1994 that I think is worth your attention because it relates to California wage and hour. And it's called Levatas v. Bradshaw. And I can even give you a site. 512 US 107. That was 1994, the year I got married, 2 years after I started with my law firm. That was a long time ago. So in Levatas, the issue was that the state labor commissioner at the time had a policy saying that if you were a unionized employee and covered by a collective bargaining agreement, you couldn't go to the labor commissioner. They took a hands-off posture towards unionized employees. And someone was upset about that and sued the state of California. And Bradshaw was, as I recall, the labor commissioner at the time. Levatas was the plaintiff. And the issue was, whether, federal labor law was violated when the state of California said, we're not going to enforce our state laws because you have a collective bargaining agreement. The Supreme Court basically opened the door for the labor commissioner to handle disputes involving unionized employees. And they said that this hands-off process or rule that the state of California had was illegal. So Levatas is an important case to just reaffirm that state law, state processes, even the administrative process of the labor commissioner is available to union represented employees. And so it used to be that, when I'd have a client with a wage claim, oh, you have a union contract, we can get out of this right away. Now it's not so easy. So it's going to be something, if you get a labor commissioner notice, you're probably going to have to deal with it in spite of your labor agreement, and perhaps more headaches for an employer, but more rights for employees. I think California is often setting the standard on the rights that employees will have, and trying to accommodate the interests of employees, particularly given that state agency proceedings are there for everyone. And not everybody can afford a lawyer. I mean, a lot of plaintiffs' lawyers, look at the potential recovery, and that's where they draw their fee from. But I think for employees, it's intimidating talking to lawyers, and when they're looking at, bringing a wage claim, maybe they're in fear of retaliation or something if they do that. The laws protect people, but the promise of those laws isn't always kept well. So this gives employees more options to pursue what might be a claim that is valuable to them, but perhaps not as valuable to a plaintiff's lawyer who doesn't see it as being very large or worthy of a large fee. So I will leave that there, but if you have any questions or anything else you'd like me to cover, I'm happy to do that.
Can we give Tom Lenz a round of applause, virtual applause? I gave my reaction there. So, Tom, thank you, and you totally underscored many of the themes that we've emphasized in this class, including the tension, right, between federal and state laws, kind of having to navigate both laws and seeing kind of which party may benefit from the procedures or laws of either federal or state. I know this class, appreciated hearing how you are bilingual. I know Karina and many others in the first class, in the first few classes, mentioned that, and actually our other speakers, at least two of them, Lenny Sansanowitz, who also speaks Spanish, and then who's a plaintiff's attorney, and then I see hands raised too. So I'll let other students speak up first. So let's see. I have Joe, and then who is JF? Again, if you can please spell out your initials in your Zoom box, that would help me out a lot. But I have those hands as well, and other students, please feel free to ask Tom any questions. We have about maybe 10 minutes left for questions, if that's okay with you, Tom.
That's great.
Okay, Joe, the floor is yours.
Yeah, appreciate you coming into our class, Tom, and sharing your experience. Just top of mind when you were talking about how unions work to address issues, and just what came up recently is the unionized employees at SoFi Stadium looking to walk out or strike, which I feel like they're leveraging the timing of all this with the Olympics coming right around the corner. Did they go through the process in mediation, arbitration to get to this point, or are they just jumping to this to take advantage of the timing of the situation?
I don't know the specifics of how their issues were addressed, but I can tell you that they are not alone in looking for beneficial timing to raise their issues. No one wants an event to be disrupted, and so if they can make their point and make a demand, the timing is very opportune.
So, because you had mentioned that for work, they want to keep it going. And so they have a process whereby they can still employ people to get the
Mhm.
job done. But in this case, how are they able to work around that? Or,
If they are around the time of contract expiration, if their agreement has expired, or if it happens to be a newly organized group of employees that doesn't yet have a contract, those are the circumstances where those sorts of strategies are best deployed. And so we will often see if negotiations are delayed and a contract has expired and there's no extension in place, that employees, especially if they're frustrated, if they feel that they've reached the end of their rope in negotiations, that's where they may talk about that sort of thing or launch into it. I am seeing that unions are authorizing strikes more frequently and sooner than in the past, to have that sort of leverage in the event that their contract does expire.
Excellent question, Joe. And I think that was even time of the World Cup starting, not even the Olympics,
yeah,
right?
right.
If I'm correct. So Julio Flores, thank you for raising your hand. Your question for Tom.
Hi, good afternoon, professors, and good afternoon, everyone. I do have a question. I have two questions. Is ERCOM considered arbitration?
ERCOM, I'm not sure what you're referring to.
Oh, okay. I think so. It's so so I work for LA County, and they have like a process. I think it's for mediation. It isn't necessarily go through the courts. It basically our disputes get resolved through ERCOM. And
Okay.
so I'm guessing maybe that is like arbitration. And they our the union says, oh, like, we filed a suit, but I don't think that's really a suit. Maybe I'm wrong, right? But they talk about, like, they use like this legal terminology, and so, like, I'm kind of confused, but I just kind of wanted to know if you knew um what ERCOM was. My second question is, so that you mentioned that that preemption occurs where, I guess, federal law supersedes like state, I guess, and maybe local ordinances. But what about like in situations where there's more benefits under the states and more benefits under the county for the employees? How does that work in federal court when there's a federal lawsuit for union employees?
Those are some pretty thorny issues, and I will tell you that if you are a public employee rather than a private sector employee,
Mhm.
there are some different rules that are similar to, but not identical
Mhm.
to, federal labor law under the National Labor Relations Act. So if you work for the county, for example, you'll
Mhm.
have different labor agreements and you'll be governed by state law for those matters. And there's a separate state labor relations board that governs a lot of the disputes that in the private sector the National Labor Relations Board would handle. And with regard to ERCOM, I would expect that that is a dispute resolution body, perhaps under your labor agreement.
Okay. Okay, cool. Thank you so much for that. Appreciate
Sure.
it. Thank you.
And along those lines, Julio, I know in one of the classes we discussed at least two forms of alternative dispute resolution mechanisms, right? Arbitration, which I believe, Tom, even for grievance arbitrations, it's binding, right? The binding, whatever the outcome is by decision by the arbitrators, it's binding. Whereas mediation, that's where a mediator gets the parties together to come to a resolution. But one of the hallmarks that I know Brian Gold and others discuss in the class, we discuss is that it's non-binding. So the mediator cannot make the parties say, hey, you have to agree. I mean, there are going to be times where it's called a mediator's proposal, where like it's the last offer by the mediator saying, "Hey, this is my last attempt," but it's not. Parties can still reject it. And another hallmark that we'll learn next week is that mediation is confidential. That's another you'll hear from Christian Quirk a lot. So maybe Tom, can you discuss more about like your work when it comes to being bilingual again? Like where else do you find it to be the most useful? And again, students, if you have other questions, Karina, I know you discussed this, other students as well. If you want to share with Tom kind of how you usually utilize your many language skills.
Um, yeah, I would be happy to answer that. I do have one point in response to the comments a moment ago, if that's okay.
Sure.
Um, yeah, with regard to arbitration as opposed to mediation, one thing that I have found interesting and beneficial is that the results are final, and unlike a court proceeding, you do not have a right of appeal.
Hmm.
Because you negotiated your arbitration clause, it's a creature of contract. You are bound by the results of that. And unless there was something that was really flawed in how the arbitrator conducted things, or maybe their ruling was really based in something that was never mentioned, some contractual provision that doesn't exist, some sort of real miscarriage of justice, so to speak, the you're bound by your arbitration result, and only rarely will a court overturn that. So you don't have a right of appeal. But in terms of how I use bilingual skills in my practice, I occasionally get cases involving businesses where maybe the owner is principally a Spanish speaker, and they want advice on how to deal with a particular workplace situation. How do I handle an employee that I want to fire? How do I do that lawfully? Or maybe it's a situation where the employer needs an agreement written in Spanish so that the employee understands what they are signing. It could be an offer letter, it could be a severance agreement, it could be a disciplinary write-up where there's some important facet of that the employee needs to really understand, and writing it in English wouldn't be enough. There are circumstances where I conduct training on any number of issues for clients. I'm frequently requested by my colleagues to do the required California harassment prevention training. And I do probably more sessions in Spanish than I do in English. Just because in a law firm with 300 something lawyers, there's plenty of them that can do it in English, but not as many that will be able to do it in Spanish. So, and that's something where depending upon where the workplace is and what works best, it's either in person or virtual. So, let's see what else. Witness preparation, even for somebody else's litigation, or possibly taking statements from people that might be used for purposes of a legal proceeding of really any kind. I would say that being bilingual has actually opened the door for me to work on other types of cases than labor. I've had exposure to a diversity of legal issues. And I'd say one other thing that I do fairly frequently is review and revise workplace policies. Sometimes an employer will have a handbook that needs updating, and maybe they have an English version and a Spanish version. So those are things that I work with regularly as well. So that's a quick sampling.
Well, we have one. If Tom, one more question, if you have time, from Jasmine Preciado. Thank you, Jasmine.
Hi.
Hi.
I guess it's more of a general question. Navigating unionized environments, do you think that having an amicable relationship versus a contentious relationship is better? And do you see predominantly contentious or amicable relationships between the union and the employer?
It will vary a lot, and sadly, something I see is that if the union is changing its representatives a lot, reassigning them, and you have a new person who wants to really prove themselves, working with an employer, it can be unnecessarily frustrating and I would say adversarial. But I think for employers that have been signed up with a union for a long time, it can be beneficial. The union representatives don't want to be filing grievances all the time in a relationship that works well. Um, they can help employees resolve issues without bothering the HR department as much. And sometimes they can be an ally to you. I think that in some circumstances where there is maybe a harassment allegation or something, they can be helpful because they have a duty to represent everybody, and they can help get to the facts. And they may be able to help steer you away from getting a lawsuit. I think that there are potential benefits. And then aside of the workplace issues, unions want the employers that they work with generally to succeed. I mean, if you have a bad relationship, maybe not so much. But what I've found is that many unions want the employers they have contracts with to win bids, to get good work, to keep their people busy so that they grow. Because the more they grow, the more they get in union dues. The more they get in union dues, the more they thrive. So they are often loath to admit it, but they are businesses too. And I think, uh, like most businesses out there, you're challenged to provide a value proposition and to do something good for the people you serve. And so, if you're working with the right union, they'll get that. There are going to be some who, sometimes they're just picking fights, and I won't, call names or suggest that one is better than another, but it does happen, and that is unfortunately sometimes the luck of the draw.
Thank
Thanks,
you.
Tom. And I didn't see Sonia's hand up, but Tom, do you have time for one more quick question?
Oh, absolutely.
Sonia, thank you. Last word, last question.
Thank you so much for joining us this afternoon. My question is, if you're new to the union environment, what's a good advice to learning how to read those contracts and how to interpret them along with your payroll department?
I would say get involved in an organization like there's an organization I'm involved in called Southern California LERA, LERA, and we do educational programs. Um, and we have a conference next month, in fact, in Buena Park in Orange County, where the issues all involve working in the unionized setting. There are union people there, there are employers there, there are government representatives, and what I'll refer to generically as neutrals, arbitrators and mediators there, where the whole objective is, realizing that we're a multifaceted world when it comes to labor relations, and people need to be able to understand each other. And issues of contract interpretation, how the grievance arbitration process works, those are all reviewed on a regular basis for really the benefit of everybody. But I think that's a good place. There's the National Labor Relations Board website, nlrb.gov. That's more technical. And then, there are some labor relations reports that are available online as well. But those are three right off the top of my head.
Well, Tom, thank you so much for your generosity of your time and for sharing your vast insights. Can we share your LinkedIn profile, your firm's website on the chat so if students
Absolutely.
want to follow up? And by the way, Tom's firm was an amazing resource for me and other attorneys during COVID when they were putting out webinars for free to the legal community for HR leaders like yourself. So I know I'm a big fan of their Workplace Wednesdays webinar that I believe Tom might, can my students sign up for that for
Oh,
free as well?
absolutely. Yeah, that no charge for that. And if you go to our website, you can sign up, and you'll get a reminder every Wednesday. And yeah, I and my colleagues are presenting regularly on things that are developing and of interest.
Thank you, Tom. Well,
My
again, last
pleasure.
round of applause for Tom. He's great. Again, he's my mentor, and there's a reason why he kicked us off with our first ever guest speaker out of, I think, many amazing speakers in the next two classes. So again, thanks, Tom. And you're
My
welcome to
pleasure.
stay, but I'm sure you're busy with other matters tonight. But we'll talk to you again later.
All right. Take care, everybody. Thank
Okay,
you.
bye, Tom.
Bye.
Thanks. Well, so how about this? Let's do a quick 5 minute bio break early. This is a good way to reconvene. And then I still took notes of the students that had their hands raised to complete our discussion of the BJ's reimbursements case. And then we'll start on the Donahue case and then finish with our class hypothetical. Okay, so let's reconvene at around 6:55, 5 minutes. Okay, everybody? I'll see you soon. Thank you. Okay, everybody, 6:55. I am posting the LinkedIn profile of Tom Lenz, and then I can also circulate the Workplace Wednesdays free program that he offers. Again, it's if you're interested, it's a great resource. I learned something new from him. That's as we know the law why we love this area, why it's hard as well. Employment law, HR law, is because the laws change all the time. Keeping up with just one area of law, wage and hour, for me, workplace safety, discrimination, as you all know, everything. And this is part of the job. I guess occupational hazard, so to speak, is that we have to keep up. But I hope that you all enjoyed Tom's presentation. Just as a kind of debrief, anyone want to share kind of something that they learned that was new, interesting, that they want to maybe now apply? They're more going to be more mindful of in their workplace or their careers. Tiara, thank you.
So I don't have a lot of experience with union, but I've always been curious about it. But I like how Tom mentioned that there's some employers that put a clause, a no striking clause, because I've always seen on the news of different employers striking or employees striking when things got bad. But I didn't know that that clause can be added into the policy or within that employer where employees cannot strike. So that was interesting to hear.
Fantastic. Yeah. And if you're ever going to follow up with Tom Lands, maybe ask him about that. I'll share that with him as well. Thank you for listening, active listening.
Thank you.
Joyce? Joyce's iPad? Joyce? Is that a new hand? And then Veronica. Joyce, I think you're still on mute. And then Sonia as well. I know Sonia asked a great question. Maybe we'll come back to you, Joyce. But Veronica, what did you want to share to recap before we move on?
Yeah, that there was no appeal. There's no appeal process in an arbitration.
Oh my
That's
gosh.
also very interesting to know because that's very huge.
It's
And
very, I
something
mean,
that-
it's a usually a creature of contract, right? The parties agree to arbitrate. You
Mhm.
have a right. It's you have a lot of agency as parties to choose your arbitrators, arbitrator. But unless it's corruption, even then, there's egregious cases internationally where like there was borderline corruption between the arbitrator and one of the parties, that maybe they wasn't disclosed because your job is to ask all those questions early on, like ask arbitrator, hey, how many times do you know this one of the parties, right? Because the bias issues. But good luck. So
Right.
that the lesson learned there is, you better do your due diligence about the arbitrator. If not, say I want to strike them. That's called striking the arbitrator because both parties have an equal chance to choose to submit names and agree to that. So it's a great question, and I'm glad Tom raised that because that necessarily wasn't going to be a big part of the class, but it's a huge thing because, as you know, right, we have arbitration agreements, we make clients sign that or employees sign that, but it can
Yeah.
be a double-edged sword sometimes, depending on the
Yes.
decision. Great.
Yeah, especially when they like regret it. So
Yeah.
yeah.
And Sonia, thank you for your question.
Yes, I think along those lines, I work with a company that's in constructions and we have union and non-union employees. But some of my management always say like, oh, they don't worry about the union employees because they say they will not go into a PAGA lawsuit. So and I think now explaining that there is a clause about the alternative dispute resolution in there. I just probably have not seen it.
Yeah.
So that was kind of interesting because I was like, what do you mean they cannot go PAGA? I knew they couldn't, but I didn't understand why.
Yeah. Okay. Well, we heard from Tom, kind of, yeah, right, one of the exemptions there, but great insights. And speaking of Paga, now hearing no other um, debriefing insights, but thank you again for those who asked questions, who shared. Let's continue our discussion of the Townley case. So I think Heidi Beeman, you were still on, and I took notes of who else had their hands raised. If we can't get to everyone for this case, can we count on you for the Donahue case? For Veronica as well. Looking forward to hearing from you again. Shelly, Karina, and Tara. So Heidi, speaking of Paga, um, what did you notice about Paga? And I know as Tom joined us, for example, I was asking Azra and then Tara also help how there's 63 stores or restaurants, and so certainly, how does that impact like the number of actual class representatives, right? Like the number of workers, servers. What did you want to share about just Paga? And we're not going to go to in depth about that. We'll go into that next week, but just generally how that played a part in this case. Heidi?
Yeah. So initially, when Townley filed, um, she was saying that BJ's didn't provide, or BJ's didn't provide shoes free of cost or reimbursement of that. And that was in violation to Labor Code section 2802. And she did mention, and that did give rise to like a PAGA action under the Labor Code. But BJ's filed a motion that Townsley's PAGA claim failed because BJ is not required as a matter of law to reimburse hourly restaurant employees for the cost of the non-slip shoes. And then it went into like OSHA and Cal OSHA. And,
Yeah, good. So speaking of that, I was going to ask you that question. Perfect. So
oh,
what is the relevant agency that they try to cite to? Which you said Cal Ultra, right? Which stands for Occupational Safety, Health Safety Agency, right? And whether or not they actually had a requirement for companies like BJ's. Perfect. Anything else before we move on to, I think Veronica, you were next about just kind of as we um Heidi, any other thing you want to add? You did a great job. You
no,
setting this up nicely. Thank you. Well prepared. I love it. I love it. Veronica, so coming back to you, is what happened at the trial court stage here? What was the ruling by the
Yeah.
trial court?
The court found that BJ's is not doesn't have to abide by repaying the employees specifically for the non-specialty shoes, but other because they're ordinary clothing in nature, which is my question is who considers ordinary clothing in nature? That's where I get
Well,
confused.
okay.
Because because who is it ordinary to? Because yes, they're black shoes, yes, but like I am an ordinary person. I would never purchase white shoes. So what if that was required of an outfit and it's out of my ordinary
I see Jasmine's hand, but I want
nature?
to stay with you, and then Jasmine will call on
Sorry.
you. No, so you have the right conclusion, but actually, it's an opinion of who actually helped persuade the court. And the clue was, I asked Heidi previously, which state agency kind of was cited that, and she said Cal
Oh,
OSHA.
shit.
But looking at the opinion, because where you found this part of the opinion, staying with you, Veronica, which other agency that may not be in California actually also has something to say about this on this issue that certainly the court looked at because likely BJ's, the employer, cited kind of their rulings, their agency decisions, writings, etc.
I think they looked at another similar case. Is that what you're referring to?
That
Something
too,
that
that too,
was,
but staying as far as again of who of for example, we in our hypothetical, right? I showed you at least a labor code section, right? Section 510, section 204, right? Just looking at what where courts are looking at. I shared with you the Department of Labor Standards Enforcement little screenshot.
Mhm.
So, who is the federal counterpart to the Cal OSHA in this case? I think Jasmine, maybe you know this, but I want to stay with you,
Yeah.
Veronica.
Sorry, I don't recall. I have to go
So
back.
okay, we'll come back to you.
Okay.
I think Shelly, you were kind of next on my list, anyways. The hands raised.
Yeah, so
You want to help us out here?
the federal counterpart is OSHA itself,
Yeah.
instead of the Cal OSHA.
And
So
what did
it's
they say? What
yeah,
was their kind of how have they decided this case or under the law, the federal law, even the California law on
yeah,
specifically non-specialty shoes that
yeah. They said only it's required for reimbursement if it's part of the work uniform or protective apparel regulated by OSHA itself. So that's another
great.
reason why it was considered ordinary in nature, another opinion leaning in there.
Yeah. And can you elaborate more? I mean, it's still
Yeah,
at least leads us on, right? So at least there
yeah.
is we know. So the attorneys briefed the court, right? Both
Mhm.
sides, at least the employer certainly, and they had that. So what does that mean? Like, how did they? Can you elaborate on what those agencies were saying?
So they were saying since she Townley had first went forward with trying to cite different codes of this under this code it's reimbursable or under this policy it's reimbursable, but both of them saying this doesn't fall under I guess our purview or I'm going to cite that this is not a way that can be carried forward even as a PAGA lawsuit, which to your point, I thought you talked about earlier about the cost, where they're
Yeah.
able to recoup penalties on like labor code violations, even though it's a percentage that goes back out to the employees after the workforce development agency.
Yeah, no, great points, right? So in a way, like the court said, I believe that it was only BJ's, the restaurant, who made this a policy, but
Yes.
not the actual agencies that were responsible for place
Yes.
safety. Great points, great points. So, as far as other students that I know had some great insights on this, can I call on Karina first, Tijera, and then I think who was it? Jasmine? I saw another student that had their hands raised
That's okay.
earlier.
I'll talk on the next case because that one's very
Okay,
interesting.
okay. Thank you, Jasmine. Perfect, perfect. So, so yeah, other insights.
Oh, sorry.
Karina, yeah,
So yeah, one of the insights was that these non-slip, the black non-slip shoes can be worn for outside of work. So even though it might not be something that the person may have chose to buy on their own for their personal use, it still could be worn outside of work if they chose to. So that was one of the reasons why, it's not part of the uniform and they don't
so
have to
okay,
reimburse.
so which way does that cut though? Meaning that like if they were to be reimbursed, then they would be kind of almost getting extra payment to wear shoes that they can also wear at work.
Yeah.
Kind of
So
fairness aspect, right?
it's only
Yeah.
if they were required, like it had, maybe the company logo or something very
Yeah.
specific that you wouldn't, wear outside of work. But I know like Target, they require their employees just to wear a plain red t-shirt, but they could wear that t-shirt outside of their job.
Yeah. Khakis too,
Does
right?
Yeah,
And I made the
khakis, yeah.
mistake several times of for whatever reason, I don't know what I was thinking, walking to Target wearing khaki pants and a red shirt.
Yeah, don't do that.
And I remember even like who remembers like Osco drugs? Theirs was like blue and khaki. I remember like one time people always ask me, "Hey, where's the I don't know, where's the toothpaste?" I'm like, "I don't know, I don't work here." Well, they look at me and were like, "Well, why are you dressed that way?" So, so this is interesting. Obviously, cost is a
Or
concern, right?
sorry, one last thing.
Yeah,
They could use those shoes for another job. It's not specific to this job. So it's not like it
yeah,
says BJ logo on the shoes and then
great insights.
they
Yes,
can't wear it at Denny's because it says BJ. So it's not just that they could wear it outside of work. They could use it for
fantastic.
another job.
Great attention to detail, Karina, in class. That's why, for example, I go to like Home Depot as well, where like their uniform only is what? It's like the schmuck or like the kind of what is it? The like apron almost, right? It's just the orange one that is a cool Halloween costume too because it's easy to put on. Right? Because curious, how many folks here work at employers where uniforms are a big cost or are required? Anybody? Anybody want to share their thoughts? Karina, of course, at the country club, right? So, what uniforms are they required to wear at your employer?
So our servers wear all black. We provide the shirt, tie, apron. We actually do require them to wear all black non-slip shoes, but we do reimburse them up to 75%, even though we don't have to.
Wow, excellent, excellent. Great way to really hit this
But
home, and that's why I think you're a great authority to share on this.
we
Perfect.
do make them wear all black pants, but we don't reimburse for the pants. That's where we put the stop on it.
Okay, okay, yeah, yeah, right. I mean, obviously, again, cost, it's like a slippery slope, right? I mean, at some point, it could add up, right? I mean, Ronke and then Joyce.
Okay, so we don't wear uniforms in our department, but I know, at UCLA, doctors, nurses, facilities, staff, so there are a lot of staff members on campus that wear uniforms, but we don't in our department.
Fantastic. Other hands, Mina, and then I think Jasmine too. But maybe, so Mina, I think I still see your hands raised.
Hi, so we have various positions that wear different types of uniform. And so for like our frontline staff, we provide them the t-shirt that has our logo on it. And for our facilities, we give them like a black button down, but we also give them patches if they want to just put a patch of our logo on any black shirts that they want to wear. aside from additional, shirts because they get dirty, they crawl into tight spaces. And they're the only, and then our facilities are the only ones that get shoes reimbursement because they need the steel-toed shoes. So
Yes.
we give
Mhm.
them, I think, $100 per year. And it's not a reimbursement, it's just we just give it to them. And I was like, well, I wish we could just do a reimbursement where they can put in their expenses, but it's just easier on our end to just every year just give them a $100 stipend.
These are great shares. I know, for example, out of COVID, the what is it, the phone reimbursements or the kind of internet reimbursements where there was just a flat rate, right? I think the best practice there was, okay, just give them $50 a month in flat rate, because how do you determine how much they're using as well? But certainly it's better to be safe than sorry to avoid PAGA. I saw in the chat, Jasmine, I know you wanted to wait for the next case, but I always want to honor um, everyone's responses on the chat. You said, can you explain to us what you wrote here?
Yeah, so when I was reading the case, that's kind of just how I saw it. Like whenever a job has a dress code policy, they can say like you guys were saying a certain color or a certain type of shoe. It's just your policy. It's not really part of the uniform. So if you think of it that way, a company's not going to go out and purchase or reimburse clothing for all of their employees. And then especially as big as these corporations get, that
Yep,
becomes a major expense. So even in this
absolutely.
court case or in this predicament, if BJ's went out and reimbursed all of their employees, that would be a massive, massive expense on their accounting team won't be happy.
Yeah, great points. As many of you in HR know, this could be a lot of work, a lot of labor intensive, a lot
Oh
of
yeah.
resources. Perfect. So I know I forget which student it was that was talking about the other case that they cited, but as we wrap up, because why I love this case, it's such a great teaching tool for students. It's a very good opinion, right? It looks to see what the court utilized in terms of like other agencies that may apply, but also it cited this Ninth Circuit case um, involving another restaurant. I think someone who said Denny's earlier. Like, can a student talk about like that case involving Denny's? It was an unpublished case, and I'll tell more about what the distinction is between a published and unpublished case. But who wants to volunteer as we wrap up? Because this is a great teaching tool for all of us. What happened in that case involving Denny's? Okay, then if no one is raising their hands, can I call on someone we've not heard from? Heather, I'd love to hear from you today. The what do you want to share about how this court u- used the Ninth Circuit case involving the Denny's case, the Limas case, on these set of facts and how they arrived at that conclusion? Heather, Heather Gomes?
um, in 2015. So it was a little before this one, just 4 years.
Yeah.
And it basically had the same arguments that the employee was a server and needed to buy non-slip shoes, and the court found the exact same reason. Those shoes, while they may be needed for the company's safety, they're not a specific uniform item, and they can be worn outside of work. So the Denny's company is not responsible for reimbursing the employee.
Perfect. Yes. So again, it's another case where the court relied on what's called persuasive authority. For example, this is a state court case, right? We in last class, right, we discussed kind of both federal and state law structures. So this is not a California Supreme Court case, but a Court of Appeal case, but still precedent setting. And the courts, the parties look to see what other cases are out there. The only one was a federal Ninth Circuit case. The issue there, it's unpublished. Well, what does that mean, Professor? Like, what are you talking about? Well, um, you want certainly, if you're ever going to work with an attorney, they should always give you published cases, right? Because that's really what you can be relied on. Even some state courts say that will say, okay, this case is not fit for publication for whatever reason. And you could actually compel a state court to publish a case so that you can use it. But my point is, if you want to sound smart to the attorneys you work with, when they say, well, because you're the client, right? We want to impress you, right? We want to show that, we know our stuff. then what if they say, "Oh man, there's no like I couldn't find an opinion on this case issue. It's so new." The way you sound smart as HR leader to say, "Well, was there happen to be like an unpublished case on that, either a Ninth Circuit case or a state law case that can be persuasive, meaning depending on just as instructive." And they're gonna be like, "Whoa, like where'd you go to law school?" Or like, where'd you learn that? And trust me, they're gonna like smile and say, "Okay, like okay, well, I'll go back and look for it again." So anyways, that's why I love this case for many reasons. But it's 7:15. Yes, I know I had everyone read Donahue. We'll get to that at some point. But because I was really geared up to start our first in-class exercise where instead of assigning you into all groups, I want to do this as a group. So what I'm going to do is I'm going to assign half the class into plaintiffs and half the class into defense, and then we'll walk through this case. So please remember your um, role. So maybe next, if you can modify your screen name to either plaintiff or employer, or rather Kardashian or Spectrum. How's that? Whatever's easy. So Amanda, you're a plaintiff. Azra, employer. Brian Gold, employee. Karina, employer. Evelyn V, employee. Heather Gomes, employer. Heidi Beeman, I have you as an employee. Helen Nguyen, employer. Ike, employee. Jasmine Preciado, employer. Jasmine Harrell, employee. Joe Kim, Insperity, employee. Joyce, employer. Julio Flores, employer. Mina Rim, employee. Ronke, employer. Sandra Beckler, thank you for spelling your full name, SB Sandra Beckler, employee. Shelly Stanley as an employee side. Shelly Calhoun, employer. Just trying to toggle down here. Sonia, employee. Suzette Manriquez, employer. Tijera Slack, where am I? Employee. And Veronica Avila, employer. So please change your designation so that I know which side you're all on, so I can begin to call all of you. So now, I know I only sent this around what 3:30 or so to the students, but again, it's okay. We're going to walk through this together. So the issue is a commissioned employee, and I'm going to share my screen now, but I hopefully you received this earlier today. So let me share the screen on this. So again, this is a hypothetical case. It is taken from a real case. That's kind of how, we have a lot of fun with this. But of course, the parties' names are not Shakira Kardashian and Spectrum. But Shakira came up because of the World Cup. So Joe, props to you about the SoFi. I know she's performing with, I think, is it Jennifer Lopez? World Cup. Or no, somebody else. But anyways, this is about the commissioned employee. And this is a nuance in our case, though, because of how the employer paid them kind of in a mixed bag, sort of commissions, but also wages as well. And so I just want to make sure that everyone sees the nuance for this case. So can I have a volunteer to read maybe, again, we're going to take our time with this. And so we may not fully get to Donahue. That's okay. I want to kind of show another sort of learning modality where we all work together. And that's why, again, I didn't want everyone to kind of just do this on their own. But the next one will be sent to you tomorrow before the next class. But imagine this is the final exam, which is not Sandra Beckler, it's not, but we're just doing this together as a group project. But this is, imagine like you read all these cases, you think you know all the cases, and now you got to apply these set of facts to all the cases. That's how a law school final exam is. And you can do it. It's doable. So can I have a volunteer to read actually the first two paragraphs, just for us to kind of slow down and read all the facts? Anyone want to volunteer to read this out loud? Or else I'll call on somebody. Sandra, did I see your hand up?
Yeah.
Okay, you want to go for it?
Yeah.
You
Okay.
got it. Floor is yours.
Shakir, let me put this down because I don't want to. Okay. Shakira Kardashian worked for Spectrum Cable Corporation, known as Spectrum for the rest of this case, as a commissioned salesperson from July 2024 to May 15, 2025. So almost a year. She received biweekly paychecks, which included hourly wages in every pay period and commission wages approximately every other pay period. Okay. So every other week she got commission. Specifically, Kardashian was an account executive selling on Spectrum's cable television channels. Okay. So she was selling, okay. Every other week, Spectrum paid Kardashian $9.90 in hourly wages, the equivalent of $24.75 per hour, assuming a 40-hour work week. Okay. About every other pay period, Time Warner. Hang on, I want to paid. Okay, so she got paid hourly by Spectrum Cable, and then every other pay period, Time Warner paid commission wages.
It should have been, sorry, that was a typo. It should have been Spectrum. So if it's Time Warner, it's Spectrum.
Okay.
Sorry about that.
Okay. About every other pay period, Spectrum paid commission wages under its account executive compensation plan. After Kardashian, so it was like a bonus to stay, or after Kardashian stopped working for Spectrum in May 2025, she sued alleging various wage and hour violations. In her class action suit, Kardashian alleged 1, she regularly worked 45 or more hours per week, but was never paid overtime wages. Okay, so almost a year, time and a half. Okay.
Good. Uh-huh.
She occasionally worked more than 48 hours per week, earning less than the minimum wage in those weeks when
You're doing good.
she was paid only hourly wages. And 3, okay, so this is the third cause of action in her suit. Due to Spectrum's implementation of a new compensation plan in March, April, May, 2 months prior, she was not paid all of the compensation wages owed on her January and February 20. Okay, so she wanted it to be retroactive, sounds like. She also wages owed on her January and February 2025 sales, not paid all of her commission. Okay, I don't know if she's saying she didn't get paid her original commission or she's asking for.
We'll get to that. Yeah, no, that's a really good point.
Okay.
That's yeah.
She also sought statutory penalties for the late payment of wages and for late payment of wages and for itemized wage statement violations. That could
Excellent. Okay, so great. So, volunteer, which case that we've read, I'd say that what the first or 2 weeks, this case to remind you of that for sure would be a good precedent, just to kind of show you, hey, like this sounds familiar. These set of facts. And anyone volunteer? That I think let's see, raise hands and see who raised their hands first. I see at least 2. Tiara, and then Azra as well.
I would say the Morales case that we discussed last week, and then also the Donahue one, even though it's a little different regarding the meal periods and the pay, it still deals with wages, so it's very kind of similar.
Okay, but so the biggest one here is overtime. So Azra, I think you had your hand up. What other case?
I was just gonna say the same thing that she said. That's why I put my hand back down.
Okay. Anyone else? What about the Yosemite water case? Brian Gold. I saw you
Yes,
had your hand
sorry,
up.
I wasn't thinking Yosemite. I was thinking the Aguilar case for the
Good.
overnight work, but
Okay.
no.
Okay, yeah, no, these are all okay, perfect. So does everyone kind of know though the key issues, right? The overtime, how she likely worked more than 40 hours. She's claiming unpaid overtime. Does everyone understand kind of her issues? But the complication here is the commission, because I know, for example, as we'll read, right, is that sometimes commissions are not earned yet, or sometimes, for example, like customers ask for a refund, they don't complete it, like it's a sale, and that actually came up in a lot of my cases several years ago when I represented a mortgage company, as well, when just kind of issues happened at closing. So another volunteer to read the next two paragraphs. Again, I want to slow down, just kind of see how these facts should jog everyone's memory on some of the cases that we've read. New volunteer, maybe someone else representing the employer, because the employer is going to respond. Aronke, thank you.
Okay, let's see. So we're starting with spectrum, remove the matter, right?
Yeah. So this is
Thank
again
you.
the
Okay.
tension between federal and state court that
Okay.
Tom kind of mentioned
Sure.
because
Okay.
Mhm.
Spectrum removed the matter to federal court and sought summary judgment concerning, oh, I can't see what it is. Commission wages. It noted that under all versions of its compensation plan, an account executive earned a commission only upon the occurrence of three events. One, procurement of the order. Two, broadcast of the advertising. And three, collection of the revenue from the client. Commissions for January and February 2025 sales were neither earned nor owed until additional conditions were satisfied, which did not occur until after adoption of the March 2025 compensation plan. Thus, the commissions were correctly paid in accordance with the operative plan.
Go on. Yeah, great
Okay.
job so far.
You want to read the next one? Okay.
Yeah.
As to overtime, Spectrum did not dispute that Kardashian regularly worked 45 hours per week and was paid no overtime. Spectrum argued that Kardashian fell within California's commissioned employee exemption and thus was not entitled to overtime compensation. California Code Regs
Yeah, you can.
PIT
Yeah,
8.
1140. Yeah, you don't have to read it. Yeah.
Okay,
That's
okay,
yeah.
okay. The
We'll get to
exemption
that too. Thank you.
requires, among other things, that an employee's earnings exceed 1.5 times the minimum wage, that is 16.50 per hour.
Perfect. So that was 2025. So pop quiz, the minimum wage went up by a little bit in California this year. What is the minimum wage now? Anyone?
1675.
Is it 20?
It went up, right? I thought it was 1690, but right. So, but either way, it incrementally went up. Perfect. Got it. Great job, Ronke. So maybe an employee. Can we have an employee now? Volunteer, employee side, class member, volunteer to read the next um two paragraphs, please. So maybe is it Jasmine? I just see Kardashian plaintiff, but
Yeah, I can read.
okay.
I also wanted to make note really quick that what they're saying is an immediate red flag. And I only want to say this because I just
Uh-huh.
went through this with a
Yeah.
company.
Okay.
The fact that their defense is saying only the minimum wage, that's a red flag, especially for sales
Yeah.
employees. They have to one be outside sales, and then there's a whole list
Good.
of things that go with that. But I just wanted to point
Yeah,
out
and fair
that
point.
being
By the way, this in the real world was a large company too, or you would think, right? Large companies, big teams, legal teams, they have everything together. But again, you never know unless maybe they thought, well, the law wasn't fully clear on this yet. So it's okay, but can we finish reading the
Mhm.
hypo, please, Jasmine?
Yeah, so where are we? Spectrum acknowledged.
Yep.
Spectrum acknowledged that most of Kardashian's paychecks included only hourly wages and were for less than that amount. It argued, however, that commissions should be reassigned from the biweekly pay periods in which they were paid to earlier pay periods. It reasoned that the commission should be attributed to the monthly pay period for which they were earned. Attributing the commission wages in this matter would satisfy the exemption's minimum earnings prong. The federal district court granted summary judgment in favor of Spectrum. First, it determined that the January and February 2025 commissions were not earned and thus not owed until after adoption of the new commission plan. Second, it concluded that Spectrum could attribute commission wages paid in one biweekly pay period to other pay periods for the purpose of satisfying California's compensation requirements. In light of this conclusion, the court rejected Kardashian's overtime and minimum wage claims, as well as her other claims.
Good. So maybe the
I'm
employer knew
mad.
something, right? At least because, again, initially they had a certain grasp of the current law, right? And so they thought, well, it hasn't been tested. So, and then even what happened next? So can I then call on an uh, employee side student to finish the hypo? Thank you, Jasmine. Or I think Joe Kim, you had your hand up regardless. So would you like to finish reading for us?
Sure. The Ninth Circuit Court affirmed as to the commission wages claim. It determined, however, that underlying the remaining issues was a question of whether Kardashian's commissions can be allocated over the course of a month, or whether the commissions must only be counted toward the pay period in which his commissions were paid. Finding no clear controlling precedent in California case law, the Ninth Circuit asked this court, the California Supreme Court, to answer that question.
Perfect. So I asked earlier, what kind of cases does this remind you of, right? So folks said, I think Morales, Ramirez, the Spectrum, the other cases as well. And then we kind of know where the plaintiff is going here. Employer's argument, right, is that, well, so far we prevailed. So procedurally, which isn't as important to this case, there are going to be times where a court, but they're applying California law. But in this case, occasionally it happens where the Ninth Circuit, the federal court will say, you know what, we're going to punt this to the California Supreme Court case because we don't know. I think a good option for them. It just so then they actually asked then the California Supreme Court to decide, okay, you decide this case, even though it went up all the way from the federal district court to the Ninth Circuit Court, right below the U.S. Supreme Court. So that's kind of the fun aspect of this case. Um, so, for example, the basic labor code sections, right, that some of you may already be familiar with that I sent over is section 510, right, about overtime, about anything over 40 hours a week, right, in California. We know that overtime payment is a certain amount. And then who's familiar here? Who thinks, that have a strong grasp as to Labor Code 204 on the law governing the bi-monthly payments? Anyone do that? Obviously, I think that's how most folks get paid. But anyone? I see Heather Gomes. Is that nodding? You want to share anything about that?
Um, it just says that basically if you're non-exempt, you get paid twice a month, and if you're exempt, you get paid at least once a month.
Yeah. Okay. Good. Joe, is that in your hand as well?
Oh yeah, I was just gonna uh, cite a specific, I guess, in terms of if it was a semi-monthly payment, then the first to 15th they would have to pay within by the 26th, I believe. And then if it was the end of the month, 15th, the last day, they would have until the 10th, I believe, to make that payment.
Perfect. Good. So again, you see how we're not trying to reconcile all these rules, right? Where it's kind of tricky. Even the Ninth Circuit didn't even know how to address this, right? A judicial panel, right? And so this is how we're going to start. Let's see. Can I get a volunteer from the plaintiff? So what's your best argument? Like, how should the court rule? What are some of your, based on what you know so far about wage and hour, what's your best argument?
I have a quick question before anyone
Yeah.
says, what is the court or the company's argument in regards to commission and overtime? And I need to know that before I
Oh,
say.
good. Okay, perfect. Then maybe can I
Yeah.
have an employer do this because usually the plaintiff goes first, right? They have their own arguments, but we'll kind of put the ball on the employer's court. Hopefully employers, right? You generally, all of you work with HR, you have a good sense as to again that you've won already. You've won a couple times. So what has been your best arguments? Employers, anybody? Let's see. Let me look for an employer here. Jasmine Preciado, what do you think? There's no wrong answers. It's just again we're all this is low stakes in terms of just us practicing think out loud. I know this is you're thinking, well, again, I didn't sign up to be an attorney, but again, we're practicing issue spotting, right? Kind of how to present our arguments here.
No, I was smiling because I knew you were going to call on me and I was going
Of
to raise
course.
my
Well,
hand
you've been on
anyway.
a roll today, so let's enjoy hearing from you. Thank you. Thank you.
So are you speaking about what the current one would argue?
Yeah. For
Like based
example,
on
like
what
if
we
you
just
were
read?
Spectrum, in our case here, like you're representing Spectrum, and then we've already discussed kind of early on as folks were reading the case, its main
Mhm.
argument, right? What type of employee is um is a Kardashian here?
Commissioned employee.
Exempt commission employee, right?
Hmm.
Right? Okay, so that certainly then puts the ball back in the court of the employee. And again, this is very nuanced, but it's I sent over the wage order now. So can we come back to you, Jasmine? If you want to see, if you're representing Kardashian, right? Knowing that Spectrum, the employer, is saying, wait a minute, this person is an exempt commission employee. What what do you want to focus on the sort of like minimum earnings? Like what kind of earnings did our employee here get?
Well, I
Me, Jasmine, or
oh yeah, sorry, my
or
bad.
both Jasmine. No, I
Oh,
think it
sorry,
was
you know what?
you.
Because I only have one screen, so that's why. Well, both of you will tag team here. Oh, that's right, of course. Yeah, Jasmine Preciado and the other Jasmine, as well. So maybe since Jasmine, you already got this. The other Jasmine who asked again, who punted this back to the employer. Now back to the Jasmine employee. How's that?
My when I see this case, the thing I would focus on is them classifying me as exempt. Isn't that a misclassification, especially because I'm a sales representative in the state of California? Because in the
So
state of California, if I'm doing outside, am I doing outside sales? Is she doing outside sales?
potentially, but it's
Okay.
beyond that though. It's her earnings. So let me give Brian Gold a chance. Brian, what did you want to say for this?
Yeah, that the to be exempt, the you'd need to earn 1.5 times the minimum wage, and that is normally construed really specifically in California, and the burden falls on the employer. And that if I worked 45 hours in a pay period, then I would be due at least $1,113 for that work, or I'd be non-exempt. And so I would argue that they misclassified me as exempt because they didn't pay me enough to classify me that way.
Winner, chicken dinner right there. I'm not keeping track of who's winning the Knicks and Spurs game, but that's a great insight. Thank you, Brian. So remember, the rate that she was getting paid at was 16.50. So the minimum wage at the time, right, was about 16.50 per hour around 2024 to 2025. So if I multiply that by what, I'm going to use my calculator again, even though it's there on the hypo. 1650 times 1.5, excuse me, is what we had there, right? But just delete this again. Around 24.75. But to Brian's point, and again to the plaintiff's point, right? That Spectrum, they kind of stipulated that, hey, she did work more than 40 hours a week, right? And that's kind of where the tension is. So go on, Brian. So then if I don't know, perfect. You are representing the employee, perfect. So can you advance your argument then?
Well, yeah, I have a lot of questions about this actually, but
Yeah.
yeah. So one is yeah that I'm not exempt if you're not paying me at least 45 hours times minimum wage times 1.5, and then also that I was paid late for some of my commission work, that it was paid in later pay periods, and that they shouldn't be able to reclassify it. And and I'm also curious from you of did they advance both of those arguments so that the employer had to argue against itself, like to win
Yes.
the classifying it late, to win that they basically sunk themselves on the previous.
Yeah. Remember again. So they're kind of like putting them in a squeeze here, right? Remember, we have the 40-hour overtime law, right? The section 510. And then, but we also have the two pay periods law, right? That kind of requires folks to be paid every 2 months at a certain time, being paid minimum wage and overtime. So here, and again, I hope everyone heard Brian, and I'm sure a lot of the plaintiffs attorneys, so I see Heidi, you're agreeing here that the only way that the first prong of the exemption to the minimum wage earnings prong is that if commission wages were paid in one biweekly pay period, and then how it can be attributed to other pay periods, so that by our so in a way to your point about putting Time Warner, or excuse me, the Spectrum cable here in a pickle is that because it issued it made the argument that it permissibly used a monthly pay period when paying commission wages, and then in order to determine wages, how somehow commission wages were not going to be attributed to the next pay period. So, other thoughts on this? How kind of looking closely at this case now, that maybe Spectrum, the employer, is not in the right here. Let's see who else has their hands raised. Other, for example, in our last case, again, applying what we learned so far, we talked about how the court in the BJ's case looked at OSHA, federal and state OSHA regulations. What did the court say here that was persuasive about, or excuse me, if you were to read the screenshot, it's a one pager that I shared. What did it say generally about how commissions could be calculated?
Just want to make sure you asked me, right?
Heather, yeah, wow, I feel like there's like some telepathy going on here.
Okay.
Heather, yeah. Heather Gomes, yes. Uh-huh.
Okay. Can you ask your question again? Because
Sure.
I got
So,
distracted.
so again, this is a great teaching tool, and again, you'll get better at this.
Mhm.
Because I have the benefit of the court's opinion, but I wanted to share for now kind of how the court would look at this, how each side would look at this. If you look at the screenshot generally of the DLSC, it's section 50. If is there anything there that you can see that kind of weighs in favor of the employer or the employee as well?
Uh, it does talk about the certain commission salespersons covered either by Order 4 or Order 7 are exempted from overtime requirements. And then says that the provisions of these subsections shall not apply to anyone whose earnings exceed 1.5 times the minimum wage if more than half of the employee's compensation represents commissions.
Excellent.
So yeah.
And then what if Spectrum here contends that the commission wages paid in one biweekly pay period may be attributed to other pay periods to satisfy the exemptions minimum earnings prong? Again, I want to make sure everyone understands kind of the unique twist in this case. And we'll go over this again next week when I send to you the case. But what is the problem there?
If I may just jump in.
This is Ike. Yeah, sorry, I'm not seeing the
Yes.
hands raised, but yes, please, since there's silence.
Yeah. If Spectrum did not pay commissions during a particular biweekly pay period, those commissions were not earnings for that pay period. According to Wage Order 4, which requires employers pay minimum wages for all hours worked in the payroll period. Is that what you're talking about?
Yeah. Mm-hmm. Yeah, so again, we're applying the wage order, we're applying Section 510,
Yeah.
we are applying the DLSE guidelines that Heather Gomes nicely read for us as well here. So, and then ultimately, though, I want to go back to the exemption language is that if you had given public policy, right? Generally, exemptions favor whom? If you were to pick a side, right? Which state of California clearly has a public policy to protect which side on these matters,
The employee.
right? Everyone agree, right? Right? And then, of course, if you know kind of what the purpose is of minimum wage earnings, right? That's to give like a floor, right, of employees a minimum expectation that I'm going to be paid a certain rate by everybody that um and certainly overtime as well, that if you work certain hours. So then here you also want to just consider kind of like the public policy um aspects of the case, right? Given how it's pretty unanimous, right? That certainly employers may win cases at certain times depending on the facts, but if it's kind of untested law, but of course it's kind of determining, okay, what is the current public policy that if you're not even being paid minimum wage for all the work, and then you just kind of reassign commissions later on to say, okay, now I've made up for the lack of minimum wage. That's not going to fly here. So, um, if you're the employer, can I get one more volunteer? Again, you're playing devil's advocate. What's your best response, if any? Again, you've already won at the two stages, the district court and Ninth Circuit, but there's a new twist here. Any other arguments that you can make? So you said that you're exempt. She's exempt as a um, commission employee, but then we learned that she wasn't being paid barely minimum wage or any overtime because of the more than 40 hours a week. Any other thoughts here? So can I hear from an employee then? What would be the ultimate ruling based on, again, on the facts? Can we come back to you, Sandra Beckler?
Honestly,
What would be the rule that we now will get if the employer here loses?
um, they'll have to. I mean, this case was so confusing to me because I'm just like I'm not. I'm just learning HR stuff, but
Yeah, no. So, by the way, this is so confusing to the Ninth Circuit case. Imagine a panel of judges that also
yeah.
there. And again, it'll get easier, trust me. But I wanted to kind of show you how we can apply all the cases, interpretations. We'll debrief this again next week as well. But what will be the holding? Remember, because you began the case, so
Mhm.
we're going to end with you on this topic on kind of how a court can the California Supreme Court can reconcile all these laws to give a fair ruling in this case.
I mean, I honestly don't know. Like I honestly like I honestly don't know. Like I think this would be super tricky. I honestly don't know.
It's okay.
I
Yeah,
don't know
well,
how they're gonna reconcile all these different moving
it's
pieces.
hard. Yeah. Someone else, just again, let's look at the initial question by the court, right? What was the initial question that the court sought to answer, right? So here, whether someone's commissions can be allocated over the course of a month, or whether or not the commissions can only be counted towards the pay period in which the commissions were paid. So you have a 50% chance, 50-50, of getting that right. But so thank you, Sandra. Someone else just wants to like um be bold and just um try to kind of find a way the twist. So again, this why this case is very complicated, right? Again, it talks about overtime violations, minimum wage violations, potentially violations of the bi-monthly pay period requirements as well, and someone who's commissioned that So commissions may or not be earned because of how there's three conditions. Just kind of putting on your HR hat, whether you don't have to be employee or employer, but what would be kind of a good rule of thumb here for an employer to know? Maybe Veronica Avila?
I don't know. It's tricky because that type of question is how could you rely on an employer to keep track of that correctly? And what if they lie too and they say that the employee never actually received that commission when they actually did? How would the employee actually make sure that they did receive that commission at the end of the day, that the client of Spectrum didn't fight back and it actually was earned? I
Good
don't,
point, actually. And yeah,
it's very weird to me. I don't know. It should be paid out biweekly when the employee is paid. I don't, and if it's paid out
yeah.
monthly, I believe that there should be some interest but at the end, I don't, it goes back to that other case where they said that the timesheets were stolen from that person's truck. An employer
Good.
could lie. I don't know.
Yeah,
It's
no,
very
commissions are
tricky.
so tricky, right? Because something could change, right? You made the sale, but then those three
Yeah.
things, certain conditions were not met.
Or
But
maybe they mix up the employers that actually received the commission. You never know.
perfect.
I don't
But I
know.
guess you raised a great point, and I think Sonia had her hand up, and we have a few more minutes left. We'll try to end early tonight, and again, I know we will go through lots of. We heard from Tom Lenz. We talked about a different reimbursements case, and we'll do this, but we're gonna definitely finish on a strong note the next two classes. So the point, though, is that we have a worker here, right? An employee, commissioned a worker who unfortunately never got paid minimum wage, right? Or even overtime because of just how many or at least overtime as because of her hours. So Sonia, and then let me see who else has their hands raised here. And I love all the class participation. I think we heard from the majority of the class today, if not all. So Sonia and then Brian Gold.
Yes. In my opinion, I think this employee should have been paid like the minimum salary threshold
Yes.
because when the commission comes, sometimes you cannot collect the payments from the customers, and then you lose that commission at times.
Yeah.
So at times it's not a guarantee unless maybe the employee is getting like a draw, like a forward payment, kind of balance off your payroll payments, but then the employer might end up on a deficit if they don't collect the payment from the customer.
Yeah, and again, who do we allocate that risk to, right? Who's better off? Maybe who's at who's at worse off if right if that's not done fairly, right? The
Yeah.
employer certainly they have a business to run, but certainly the employee, right? If they have certain rights as to minimum wage, overtime, great
Yeah.
insights. Thank you, Brian Gold.
Yeah, I guess my challenge is the law never really makes sense to me, but so California minimum wage, the normal standard is two times hours work or two times minimum wage, right?
Yeah,
And they force you to do that based on 40 hours. So if I have an
yeah,
employee who works 30 hours a week, I can't do 30 hours times two and say they're exempt. So how do they use the same rule and twist it and say that it's based on 45 hours, not on 40 hours or on actual? It seems like it auto apply both ways, but somehow it doesn't make sense to me in this case.
yeah. Well, again, we start with if it's a kind of close call or unknown. I mean, I think the public policy rationale works, right? Is that which ultimately you look to see, courts will look to see, okay, what is the public policy on this? Like, why do we have minimum wage, right? Is it to help the employers or employees? Why do we have overtime laws, right? Why do we have these laws? And that I think kind of um, helps form the opinion. But you're right. I mean, and there's been times too where, for example, I've had my employer clients overpay an employee, and the law is not very forgiving. I mean, like unless it's a really major mistake, unless it's hard to get that money back, right? So it's I think there, but here's what I'll do. I know it's a lot. I'm gonna send you the case of actually. That's why I kind of was giving the clue about Time Warner. This is actually a real case called Peabody versus Time Warner. It's a very relatively short opinion. Let me see how many pages this is. It's about 6 pages. So for the next class. I want folks just to read it. I mean, it's not, it's but for you to kind of get a good debriefing on this case as to how the court looked at Martinez, Section 204, the DLSE opinion as well. And you'll find, and I'm sure, I know they didn't hear from everybody because a lot of people had their hands raised. You'll find that you actually know a lot more than what you think you know. And you, all of you, were on the right track with this because, again, I had the benefit of certainly years as an attorney, knowing this law, but having the actual answers on the case. But don't be surprised if you actually knew exactly which side the court were going to be headed towards. Okay, so we have about 5 minutes left. Again, I want to really finish the last two sessions very strong. We have two guest speakers next week. One is Lenny Sansanowitz, who's a plaintiff's attorney. He represents workers, and I want him to talk about PAGA, about kind of benefits to going to state court as opposed to federal court, the different emotional damages, but ultimately, because they're all getting a good exposure to wage and hour law, what other employment law violations are usually attached to wage and hour violations? It could be retaliation. I think we discussed this last week. It could be other discrimination claims because we've heard, I think Tijera and others have said that if an employer will take a certain action, and she shared with us, I think in Nevada, right? And then an employee complains, and then the employer may then try to say, well, this is something else. So that's one speaker. And then we're going to hear from Kristen Couric, who's a full-time mediator, but also was actually kind of an attorney, HR attorney as well for several big companies. So I'll send you their bios as well, and then I'll modify the cases because as I mentioned, and before we go, in so the trade-off for not assigning a textbook or a casebook, because number one, I love assigning cases and the challenge of this, but also not having to pay extra for books that we may not cover for 6 sessions. If you do get assigned what's called a casebook in law school, the cases that you're assigned to, they're excerpts from the cases, meaning that you're getting like kind of the junior high version of the case. Whereas I'm having my students who I know are not going to necessarily take the bar exam be challenged by reading what judges and attorneys read. So you have to kind of filter through the other procedural, other legal aspects of a case. Again, I try to pick cases that are not too long, but I can't promise that. So some of these cases will be 15 pages, some are 6 pages. But just know that your reading comprehension, your skills of reading complex materials, they've grown a lot since our first session. So I'm going to modify some of the cases where we may not have to be reading all 6 cases left, but I still owe a discussion of Donahue, which is a big case. But I wanted to just make sure that we absorb everything today. So in the 2 minutes that we have left, can I get maybe one or two students to share kind of what they feel they can take away from this class, whether from another Tom Lentz insight or from our class discussions on the Townley case or this hypo case. Volunteers before we go? Let's see. Shelly?
Just really quickly, just with the 510, my first employer I worked for as I went into HR, I did not know why I got paid on the 10th and 25th of each month. It was the most annoying thing. And now knowing that there's actually code to that, when I was a baby in my HR career, I'm like, oh, this is what they were going through. So yeah.
Great share. Thank you. At least other students, please. Let's see. Sandra Beckler, thank you, buddy, for reading and for many shares the last 2 classes.
Thank you. I also from Tom Lance, I thought it was interesting having worked in the public sector some and then going into the private sector. I thought Tom Lance was good in pointing out this that I thought was cool that he said that the federal labor law or the federal came in on one of the cases that he was working on and told the California Supreme Court that, you can't practice that law. And I think that's interesting because I feel like when we think about the federal government, we don't think about them coming in and stepping in often. We think about them as like the iCloud, right? It's like they're
Yeah.
there, but we don't ever see it. And I mean, it's like I worked for the federal government when I was like 22, and I remember like it's weird because it's like you don't really think it's real until you're there. So like they paid for me to relocate and I was on an airplane. I noticed I'm on an airplane with senators and stuff like that, which for me, my 20s was like shocking because I sat down next to this guy, he's writing all this stuff and I'm like I'm like, who are you? What are you writing down? You know, because
Yeah.
I'm like this dumb kid, but
Yeah.
and he's like, he kind of like looks at me like, and then I started
Yeah.
looking around the plane. It was a small plane. I started looking around the plane. I'm like, but I thought it was interesting that Tom brought that up. I thought it was interesting that he said, like, yes, the federal laws can step in. They can be a major part of any state, what they're doing. And, you can tap into that resource if you're an employee or if you're an attorney, depending on what the situation is, and you're trying to get to the root of whatever the issue is. And I thought that was
Thank
interesting.
you.
Yeah.
Yeah, we'll debrief more about preemption later on. I know in my other class we do this. That's a constant tension as well. Last but not least, I know we're over 1 minute over time. I think it was Jasmine on the employee side. I'll share with the class the Peabody opinion, and you'll kind of see how I think y'all have a good sense as to how to analyze this case. But I'm happy to answer any more questions at the next class. So with that, look for an email from me tomorrow again about the next class. We have at least 1 week off, right? A gap. So that's where I think we can assign a little bit more readings because we were going kind of every other 3 days or so. So look for that. But in the meantime, I'm so impressed, really, by everybody, by the quality of questions, preparation tonight, the most we've heard from everybody, and I'm confident that you're all learning so much and that you're going to be experts moving forward on these topics. So thank you, everybody, and great job as always. Let's again finish the next two sessions strong, and welcome our other guests, and I'm sure you'll have great questions for them as well. All right, everybody. Good night, and email me if you have any questions as well. So I'm going to save the chat so for my notes and just to save everybody's great insights. Okay, everybody. Thank you. Good night.
Thank
Good
you.
night.
Thank you. Thank you.
Good
Thank
night,
you. Good
everybody.
night.